Morning, sir.
My name's Howard Brown. My name is Howard Brown. I'm serving as the hearing officer today. Can you hear me all right?
I can, thank you.
Great. Okay, are the parties ready to move forward this morning?
The county's ready. I'm ready.
Right. Well, today is August 20th, 2024. The time is 8:04 a.m. This is the zoning violation hearing on zoning violations citation PZC 24-0026, Coconino County versus Ernedit LLC and John Hassett. The hearing is taking place by Teams video conference and at Thomas Auditorium. And the hearing is being held pursuant to the Coconino County Zoning Ordinance 5.14. I have received the county's exhibits. I'm not in receipt of a county witness list, so therefore I assume that only Mr. Stento will be testifying for the county. I have not received any exhibits or witness lists for the respondent, and therefore I assume that only the respondent himself, Mr. Hassett, will be testifying.
Yes, sir.
Okay. All right, thank you for the clarification. I have received from Mr. Hassett a denial of responsibility, and so therefore he is entitled to a hearing today, which brings us to this hearing this morning. The procedures that we're going to follow for the hearing are that first you'll each have an opportunity to give me a brief opening statement. That's not an opportunity to show me your exhibits or tell me your proof. It's just an opportunity to kind of tell me what you think you're going to prove today. Okay, just to kind of frame your side of the story for me briefly. Okay, if you do that, and then when you're done with those opening statements, it'll be Mr. Stento's turn to go first, and he will present his testimony under oath as well as his exhibits. Mr. Hassett, you'll have an opportunity then to ask Mr. Stento questions. That's what they call cross-examination. You may have seen that or heard that term before. When that's all done, I might have some questions for Mr. Stento. And then, Mr. Hassett, it will be your turn to present your case to me. So you'll give me your testimony under oath. You can talk about any of the exhibits that Mr. Stento has shown me. And then when you're done, Mr. Stento might have questions for you, and I might have questions for you. And then when we're all done with that, you each have an opportunity to give me a closing statement, which is just kind of a few-minute wrap-up of what you think you have proven to me today, or why you think you're right about your position in the case. Okay, so that's the order of proceedings that we'll go through today. Okay? All right. And of course, I expect everyone to act civilly towards one another, respect the process, respect each other, respect me, so that we can have a full and fair hearing today, and everyone will have an opportunity to speak. Okay? Thank you. Ms. Hernandez, we are recording, is that right?
We are recording, yes.
All right. Well, then we will proceed. Mr. Stento, do you wish to make an opening statement?
I do.
All right, please proceed.
I would like to bring to the attention of the hearing officer case PCC 240026 for the property address 4125 South Perkinsville Road, parcel 204-13018 Echo, located within Coconino County and zoned as G General, a residential zone, with an approximate lot size of 10 acres. Property is owned by Ernedit LLC, a domestic LLC whose statutory agent and owner has been identified as Mr. Hassett. For at least 2 years, Mr. Hassett has been utilizing the property unlawfully as a campground for friends and family to stay in recreational vehicles, travel trailers, and fifth wheels. He's created infrastructure without permits to support this ongoing use despite impacts caused to and complaints from surrounding residential properties, as well as warnings from the county. The county zoning ordinance prohibits campground use and occupancy of multiple RVs, travel trailers, and fifth wheels on residential parcels. Mr. Hassett's claiming the property isn't a campground because he's not collecting fees from the campers, and the campground sign displayed at the front of the property was a gift. But as the county will demonstrate, and Mr. Hassett's correspondence with the county will corroborate, The evidence shows a pattern of use consistent with the zoning ordinance definition of a campground, and the utilities and activities associated with it constitute separate building and zoning violations. Moreover, the county will show code enforcement officers went to considerable lengths to provide Mr. Hassett ample warning and adequate resources to achieve voluntary compliance. The county concludes its opening statement.
Thank you. Mr. Hassett, would you like to make an opening statement?
I would, sir.
Please proceed.
So obviously, I'm not an attorney, so I'm probably going to incriminate myself on making statements of this. But the county staff has been very polite, very professional. Mr. Stento has been very helpful as well. I entered a plea of a denial plea of, I'm assuming, not guilty, based on the fact that if I didn't respond, it immediately goes to an acceptance, from what I understood. Since emailing that or sending that over, Mr. Stento has made it very clear that, hey, this is a campground, even though you're not generating revenue. I do understand that there's things here that are in violation, and I'm fully willing to and able to mitigate. Since he was kind enough to send me the exhibits, there were some other things that I am genuinely confused on, and things that I do acknowledge and will make right for this county and my property. I purchased the property with the intent just to have a place for my family. We'd love to build on it, but the cost of building got a little bit too high. So our long-term goal is to build a place for our family. I understand that there's many avenues that I can take for proper use and licensing of my own personal trailer, which I intend to do if the county allows me. And I do understand that as it may appear a campground, yes, there is a sign there. I'm not denying that. It's in your exhibits as well. That's my last name. My kids call it Camp Hassett. It's just really an internal thing. The sign is a gift. I'm in no way trying to generate revenue or make a campground. No, we're just all trying to escape the heat. We're not drug dealers or bad people. We're actually, a lot of us are in government. So also my apologies if I do answer my phone. I work for the medical examiner's office. So if they do, it's on do not disturb. Certain people can get through. So my apologies if something does come up. Like I said, I'm knowingly probably going to incriminate myself today, but I do have every intent to mitigate and make this correct. I want a better understanding and clarification, and that's why I wanted to come up today. So I think that concludes my statement.
Thank you, sir. That's appreciated.
Pleasure.
Mr. Stento, is that your understanding of Mr. Hassett's position on all of this?
Can you clarify your question?
Well,
sir?
that he's essentially, he understands that there are violations there. He's willing and able to mitigate. He wants to make things right. Is that the county's understanding of Mr. Hassett's position?
We have not, Mr. Hassett and I have not spoken directly over the phone. We've exchanged some emails, which are present in the exhibits and I will ask to be admitted into evidence. Beyond that exchange of emails, we have not had this conversation prior. So, no, that is not my understanding, but I'm willing to take Mr. Hassett as well.
Gotcha. Okay. All right, Mr. Stento, are you prepared to proceed with your testimony?
I am.
Please raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth in your testimony today?
I do.
All right, please proceed.
Certainly. On 11 July 2022, Coconino County Code Enforcement received a phone call from a concerned citizen alleging a recreational vehicle campground was operating at 4125 South Perkinsville Road. I asked for Exhibit 1A to be admitted into evidence, which shows the physical location of the parcel as well as the zoning and the property owner for reference.
Mr. Hassett, you have the exhibits in front of you.
Yes, sir.
Have you had a chance to review the exhibits?
I have, sir.
Do you have any objection to me considering any of those exhibits?
No, I don't believe so. They're all accurate photos, emails, correspondence via mail and email. So I don't have any objection. My clarification purposes are in some of the exhibits that are at the end. So, but I don't object to them being entered into as evidence.
Okay. Then without objection, Mr. Stento, I'm going to admit all of the exhibits so you can just proceed through and discuss them as you go.
Certainly. A site visit was conducted by compliance manager Stento Me on 12 July 2022 after receipt of the initial complaint. I noted the parcel contained 12 recreational vehicles and travel trailers, playground equipment in the middle of the parcel, a large metal storage container, a Camp Hassett sign, and signs of recent traffic and activity, though the recreational vehicles were not occupied at the time of the site visit. Photos from this initial inspection are shown in exhibits 1B and 1C. Again, this was 2022. A courtesy letter was sent to the owner's address on 11 August 2022. Code enforcement received a call from Mr. Hassett in response. The alleged violations, including RV occupancy and campground use, were explained to Mr. Hassett by myself. Mr. Hassett inquired about the possibility of a legal path forward. I noted under some limited circumstances, conditional use permits could permit a commercial campground in G general zones like this one, but that typically didn't apply to private recreational vehicle campgrounds. Nonetheless, Mr. Hassett was encouraged to contact planning and zoning. Mr. Hassett stated the alleged campground would not be used while he looked at his options. Moving forward to 23 August 2022, the same year, an incomplete conditional use permit application for the property was recorded in the county's permit system, PC-CUP 22099. The project name, as completed by the applicant, was Hassett RV Storage and RV Camping. The project description, as completed by the applicant, was RV Storage and Camping. This application is shown in Exhibit 1E. On 04 September 20.
Mr. Stenta,
Go ahead.
so 1E, that was an application for a conditional use permit,
That's correct.
not an administrative permit?
That's correct.
So at that time, was it being treated as a non-conforming parcel?
No, it was not. Under some circumstances, to provide some background, in G general residential zones, via a conditional use permit, some campgrounds, tent campgrounds, not recreational vehicle campgrounds, some tent campgrounds have been permitted. There is an allowance in the zoning ordinance for certain types under certain conditions, hearing and a review of a conditional use permit application for a campground in G general zones. This was an application, a pre-application for such a conditional use permit, which this use wouldn't fit into, but we understand the intent behind it.
Gotcha. Okay, sorry to have interrupted you. Please go ahead.
I'm sorry, may I interrupt really quick? Is it possible to get a copy of the recording or should I be taking notes?
When it's all complete.
Oh, you want it? Okay, perfect. Thank you, sorry.
On the 4th of September 2022, code enforcement received an email report from a different complainant alleging campground operation in Mr. Hassett's property. The report included a photo showing multiple vehicles parked in front of various recreational vehicles on site. The covered pergola type structure in the left side of the photo helps identify the parcel as 4125 South Perkinsville. This is also identified in other photos. Photo is shown in Exhibit 1F. We can see recreational vehicles, fifth wheels, with personal vehicles parked next to them. And this was again submitted by the complainant to the county. The photo taken on 04 September 2022. Follow-up site visits in October 22 and November 22 showed that while equipment, shed, and miscellaneous items remained, most recreational vehicles were removed and activity appeared at a minimum. The case request was kept open, but staffing issues and caseload required code enforcement to shift priorities to other more pressing cases. But again, the case was kept open. We still had unpermitted structures there on site. In May 24 this year, Code Enforcement Officer John Cole performed a site visit to check on the status of the case and determined if violations had been initiated against seasonally. Cole confirmed 8 recreational vehicles and travel trailers on site, 2 unpermitted metal storage containers, and signs of recent use, including a campfire. The playground equipment, pergola, and other miscellaneous items noted on the property also remained. John's inspection photos from May 24 are shown in Exhibits 1G and 1H. A notice
Mr.
of
Stento,
violation-
Mr. Stento, is that pergola on some kind of a slab?
It is.
Is it concrete? What is that?
It appears to be, yes.
It is stamped concrete.
Okay.
A notice of violation was issued for the use of an RV as a dwelling, campground use in a residential zone, and unpermitted work via certified mail on 15 May 24. And signed for by Mr. Hassett, or representative of Earn Edit LLC on 30 May 24. Then the initial notice of violation is shown in Exhibit 1. A site visit was conducted by code enforcement on 06 June 24. No substantive changes were noted. RVs and travel trailers remain corralled around the circular pergola along the property, or the circular drive and the pergola on the property. On 21 June 24, code enforcement received the following complaint from a third complainant, quoted direct, including errors as submitted to the county via its online case request system. I quote, "Good morning. The property in question has for the past few years had many RVs parked there throughout the year. The owner's prior request for permitting the property for RV storage and camping expired without approval in 2023. The concern is that as neighbors, we continue to see multiple RVs parked here for months. I do not know if this property is rented out to these parks, and that's the submitter's error, or who they are that stay there. The individuals staying in the RVs at the property continue to trespass onto private property despite no trespassing signs being posted. They have damaged signs, vegetation, as well as the dirt road beyond their property as they ride back and forth, destroying the top layer of gravel that gets placed to cover the road. They increase the risk of fire as they trespass and ride through private property where there's tall grass and vegetation, especially in the summer months as it dries out. I have witnessed individuals trespassing on other property as it appears they were going to the bathroom. I can't blame visitors for wanting to enjoy the outdoors, but there is plenty of national forest where they can stay instead of trespassing and disrespecting as well as damaging others' property. I'm not sure if the owner visits the property as well, but either way, those visiting the property should have no respect. If RV storage is not allowed, then this is a problem. If the owner has no regard for the other properties and cannot ensure respect of the visitors at the site, then that is a problem." End quote. Another site visit was conducted by Code Enforcement Officer John Cole on 24 June 2024. During the site visit, in addition to signs of recent use of at least 10 recreational vehicles and travel trailers, Cole documented utility hookups, much like those seen in RV parks, as well as a commercial generator shown in exhibits 2B and 2C respectively. And in 2B specifically, we can see an electrical hookup. No permits were issued for that. Running electrical like that would require building permits. And 2C, we can see a commercial generator. Commercial generators also require building permits in Cook County.
Mr. Stento, that 2B, so is there electrical like stubbed out to the property line and then they're plugged into it, or what am I looking at there in 2B?
That is my understanding, yes, as you stated.
May I clarify?
Yeah.
Okay, there is not electrical on the property. It's across the street, but I'm not able to pull power without building a structure because pedestal power, from what I was told, is not allowed by APS. That I put in, I do admit putting that in, but it's because I got tired of having extension cords everywhere that just runs through the generator.
I might ask you some more questions about that when we get to your sworn testimony.
Sorry, thank you for clarification.
Appreciate it though. Thanks.
Let me pick up my spot. Electrical installation of commercial generators require building permits have been noted, but no relevant permits have been issued to the property. A recently used campfire ring shown in Exhibit 2D was also documented. On 28 June 24, Code Enforcement Officer Cole performed another inspection, this time noting UTVs and personal vehicles parked next to the recreational vehicles and travel trailers on site, several of which are shown in Exhibits 2A and 2E. A citation notice to appear in admission or denial of responsibility was issued the same day, 28 June, and accepted by the respondent on 1 July 24. A denial of responsibility was received on 15 July 24. These items are shown in Exhibits 2, 3, and 4. Additional inspections of the property were conducted by code enforcement officers on 05 July 24 and 15 July 24. Both site visits documented personal vehicles, including off-road type vehicles alleged to belong to campground, which were alleged, to belong to campground RV and trailer occupants. Those site visits are documented in 5A and 5B. And sir, I don't know if I referenced exhibit 2E, 2 Echo, but 2E also showed photos of the property taken in June 24 with side-by-side type recreational vehicle and personal truck next to one of the truck trucks. Beginning the 2nd of July 24, Mr. Hassett began engaging via email with compliance manager Stento and myself. My complete email correspondence with Mr. Hassett is documented in Exhibit 5C. In addition to speaking with Mr. Hassett at LinkedIn 22 on the phone regarding the illegality of the uses on the parcel after initial investigation and the courtesy letter, I also outlined via email the violations on the 2nd of July and again on the 5th of August to Mr. Hassett. I also have repeatedly invited Mr. Hassett to give me a call and discuss the violations so that I can answer any questions he may have. However, my department, code enforcement, never received a call from Mr. Hassett after the initial conversation in 2022. Though it is my understanding after talking to planning and zoning this morning, he did speak with one of our planners recently. We performed another site visit on 19 August 2024 this year and documented 8 fifth wheels and travel trailers on the property, 6 with expired registrations. Again, this was yesterday. Storage of recreational vehicles in conjunction with ongoing campground use on the parcel persists. No relevant building permits for the electrical or metal storage containers, one of which has been modified, have been initiated. The totality of the circumstances on the parcel continues to show clear utilization as a campground. That concludes the county's testimony.
Mr. Hassett, do you have any questions for Mr. Stento that are specifically about his testimony?
No, sir, I do not.
Okay. Mr. Stento, let me ask you a couple questions. Tell me again what was observed yesterday.
Yesterday, there were 8 fifth wheels and travel trailers observed on the property. There were no personal vehicles or OHVs. 6 of those travel trailers and fifth wheels had expired tags, no current registration. 2 had current registration. 2 metal storage containers were observed. One 160 and one 320 square foot metal storage container. The large metal storage container, the 320 square foot, had whirling gates in the top. Looked like the metal storage container had been modified that would require a building permit. The electrical hookups that were noted in the exhibits were still present. All the items referred to in exhibits in my testimony, except for the personal vehicles, were still present on the property, including the pergola, the playground area. The large water cistern was staged and looked like it was going to be installed. That too would require a building permit. Do you have any further questions about my observations?
Were the fifth wheels and travel trailers, were they the same ones that were shown in, for example, Exhibit 5A?
Let me reference Exhibit 5A so I can be clear, sir.
And did you do the site visit yesterday?
I did.
Okay.
Referencing Exhibit 5A and 5B, I believe I recognize 2 of them. The smaller unit with the small spare tire in Exhibit 5B, I do not believe I saw there on site. The dark fifth wheel on the left, you can barely see on the left side of 5B, and the one center frame, I do believe I saw. To some extent, they all look somewhat similar, but that's
Was
my assessment.
generator still
Yes,
there?
that's correct.
Okay. Now, and just referencing the zoning violation citation, that's Exhibit 2. At near the end of your testimony today, you were kind of emphasizing campground, unlawful campground. Is the county still taking the position that there are RVs and travel trailers unlawfully used as dwelling or accessory structures?
Yes, we are still alleging campground use. The allegation of RVs and travel trailers unlawfully used as an accessory structure. We included that in the citation, initial notice of violation, should we not be able to make the findings. The totality of the circumstances supported ongoing campground use. It is still unlawful to occupy an RV or travel trailer without a permit. If it's one, it is outright illegal to occupy multiple travel trailers or RVs on residential property in Coconino County, period.
If I remember correctly, and I got to cross-reference the zoning ordinance, but the prohibition is using an RV or a travel trailer as a permanent dwelling. Do you have testimony, evidence indicating that these are being used as a permanent dwelling?
They're also prohibited as accessory structures in the county zoning ordinance. So basically all you can do pursuant to the zoning ordinance is park a licensed registered operable RV, travel trailer, fifth wheel on private property if it's personally owned. It's easier to explain what you cannot do. And that is basically anything else. So an RV storage yard is a recognized commercial use. Well, that is not listed on the citation or in the notice of violations. For the sake of this conversation, that is also unlawful on a single family residential parcel. Parking other people's RVs, travel trailers, fifth wheels would be considered an RV storage yard and a designated commercial use, prohibited. Except RVs, travel trailers, fifth wheels cannot be used as accessory structures, so I could not use one as an office on my private property. I could not use one as a play area on my private property. I could lawfully permit a single in a G-zone parcel like this. I could lawfully permit a single RV, travel trailer, fifth wheel, tiny home on wheels as a permanent residence. But I could not lawfully occupy. And that means accessory use, office use, sleep in it occasionally. I could not lawfully occupy an RV, travel trailer, fifth wheel, or especially multiple ones in any way, shape, or form on a residential parcel outside of that specific administrative RV as a permanent residence permit. Does that clarify?
Yes, thank you. Mr. Hassett, do you have any follow-up questions to what I just asked Mr. Stento?
Not this time.
Okay. Okay, well, with that, Mr. Stento, I understand that concludes your testimony. Is that correct?
That's correct.
Okay. Mr. Hassett, are you prepared to testify?
I'm willing to give it a shot. Yes.
Okay. No, you don't, nothing formal. I just want to hear what your position is on these violations. And you know, you're not incriminating yourself. You're just going to be telling me what your perspective is on these alleged violations. Okay. So if you could please.
My staff have available when you're ready to filter. So.
Please raise your right hand.
Yes.
Do you swear to tell the truth, the whole truth, and nothing but the truth in your testimony today?
I do.
Okay, please go right ahead.
Okay, so I guess I'll just start at the front. Obviously, the trailers, everything Mr. Stento said is very accurate. I just want to clarify for the record some of these things. The pergola has been removed. It actually collapsed under snow, even though it was snow load rated. I just haven't had a chance to get it out of there because there's no trash service, so I need to haul it out. But it is dismantled and moved to the side. That was as of last year, actually, I believe. It is on stamped concrete. I poured the concrete myself. I honestly had no idea you need a permit to pour concrete on something you're gonna walk on. I can understand if it was a foundation base, but we really just didn't want to stand in dirt and mud. That's why we did it. As stated earlier, the sign was a gift from my wife because the kids called and can't pass it, so we threw it up and thought it was, and everyone says I'm like a Sasquatch, so that's, that's why the Sasquatch is on, that's where the logo came from. Most of these trailers are still, to my knowledge, are still occupying the property. 3 of these trailers belong to myself, and I can point them out in the photos. They are not registered to the LLC, which I can understand would be confusing if you were to run registration, which I don't know if you're allowed to do that, but I can explain the registration between myself and different entities. The playground, the shipping containers do still exist. The containers were placed there right when I bought the property. I guess modification of the containers were the whirlybirds. Again, I installed that myself. I had no idea you needed a permit for a whirlybird. They are not connected to power or anything like that, but they are there and they do still exist. The playground was installed by a company out of Phoenix. That was just really for my children. I don't know if that's an issue it is referenced, but I don't know if that was a permitting issue, so I can't attest to that one. Okay. Good now. Okay. Again, the power, as stated earlier, I got sick and tired of rolling up extension cords, so that's why I did that. I thought this was a lot better looking and more professional, less of a hazard, and they wouldn't get stolen because I didn't want to have to roll them up and in and out. The water is for future use. It is not connected to anything. The generator has been there since the very beginning. I was in the construction business at one point, so it was something we had, and I brought it up, and it was what I thought to be the best power serving products that I couldn't draw power to the area. Campfires obviously was used, can't argue that. The cistern reference, I did, again, I was in construction, it was a spare product, I did bring it up, I would like to at some point hook that up for water service in that area. On exhibit 5B, the trailer to the far left is mine, the trailer with the spare tire is mine, and I believe the Weekend Warrior is still there, I don't know about the other one. And I think that's the only exhibits in reference. Okay, so basically, I bought the property in 2020 after touring Williams for the first time. I loved the area. I wanted somewhere to escape the heat, enjoy things with my family. It was initially, the intent was to immediately build a small home on it so we could actually pull in power, get septic, get water, et cetera, et cetera. Cost of building skyrocketed. We decided, hey, let's buy an RV instead. We've brought the RV, purchased the RV, brought that up there. Enjoyed the first summer, 2 summers up there excessively, like every weekend, to try to, get out of the bullhead heat, and had a great time. Code enforcement did reach out to me. I did start that process. I, for one, am still a little confused on the whole permitting, conditional use, administrative use, special use, et cetera. But they've done a really good job explaining and expressing and being available. I did speak to a planner. I thought to myself, hey, I'm just going to rezone this to commercial so that I can actually do this. And did not receive any resistance, just received like, I don't know if this is going to work type of situation. It is still something I'm willing to try. I think I've made it up there personally about 3 times this last year. It's unfortunate. I'd love to spend more time up there, but business kind of took me away these last couple of years. Like I said, Mr. Stento didn't make any accusations that were inaccurate or outlandish by any means. He's absolutely right. I understand exactly where the county's coming from. That was quite a mouthful of what you cannot do versus what you can do. So I'm going to probably have to go back and reference tape or something to get that listing. But honestly, I just really want a place that I can spend time at with my family. That's the whole goal. I understand that there's probably way too many unwelcome. Well, they're welcome in my part, but the county's eyes, too many trailers and unwelcome in that aspect. Personally, I would really like to follow the legal path to file commercial, do whatever needs to be done until I hit an absolute roadblock of where it's not possible, and then I would probably move on to the building. It is my intent to keep the land and keep it in the family and utilize it to the best of our ability. Personally, I would rather camp than stay in a cabin. So, camp to the extent of a trailer versus a cabin, but I guess I'm not upset at the staff in any way, shape, or form. I think I'm more upset at the rules and regulations because I don't want to be a snitch in any means, but I know this is occurring in other areas of Coconino County, and I'm sure the staff have their hands full dealing with other situations. So I I guess I'm just confused and bothered and upset by regulation that I can go do this exact same thing 200 feet north or 200 feet south, et cetera, et cetera. I've asked a lot of locals and they said, oh no, as long as you move the trailer around your property every 14 days, you're fine. And I think that's the federal regulation for National Park Service, but whatever, I'll give it a shot. So like I said, I'm here today to let the staff know that I'm hopefully not a pain and I do want to make this right. I do want to do the right thing. And I understand that penalties could be enforced on me and I'm willing to accept that for my shortcomings of not following through with my filings and or whatever the CUP was. But I really just would love to find a solution that will allow me to use this in somewhat in the capacity that we're using it. I didn't see the statement from the individual that Mr. Stento read. I would be curious to reference. I'd be curious what they are referencing. There were no trespassing signs that were put up. I made it very clear to my children. I mean, I can't speak for other individuals that are up there without my approval. I have asked individuals to remove their trailers. So I know it's fact for my children. They enjoy going up there and they're very expressively, I've told them very intently to make sure you stay off properties and respect those signs. So I'm not familiar with what damage has occurred. I sincerely apologize if I've never made that claim. That's not my intent. My intent is to respect the area and be people's private property. I just want to use the land that I purchased, to be honest with you, and I want to try to do it the right way. I think that's the rest of all the rest of my testimony. If you have any questions, I'd be more than happy to be available for that.
Thank you, Mr. Hassett. Mr. Stento, do you have any questions for Mr. Hassett?
I do not, but I can clarify a few points regarding building permit. So the slab does not need a permit. That's not something we're referencing. We don't care about that. The playground equipment also is not something that we require building permit. We're specifically looking at the electrical, the commercial generator, and the metal storage containers. Those are the three primaries.
What about the pergola? That was referenced. I'm only curious.
No, the pergola was referenced, as was the playground equipment. It's an assessment of the totality of the circumstances. We would find that likely in a campground versus on an empty parcel. Right? So that was where that was going with that. Okay. The water cistern, if buried, would require a permit. As it sits on the property, it's just a giant plastic. It does not. But if you were to bury it, that would require a building permit. Okay. That's the extent of our building permit concerns on the property.
So thank you for clarification.
Absolutely.
May I ask a question with regards to that?
Sure.
So this call it ignorance on my part, but what is the definition? I mean, what would be the deciding factor between daisy chained predator generators and that generator? I mean, personally, I would rather have that larger one due to redundancies and safety and sound, but so I can do little generators, but not that generator.
You can do that generator. You just need to get a permit for it.
Oh, okay, that's it. Or a little one and no permit.
Or a little one and no permit if you're running, but again, it would have to be used in conjunction with lawful RV use, which would put other stipulations on the use of that generator to support that RV spout.
Okay.
I'll encourage you guys to keep the conversation going after our hearing. I think it is very helpful. So keep that conversation going. Mr. Hassett, let me ask you a couple questions. So I think I heard you say that 3 of the travel trailers are yours.
Yes, sir.
Who owns the other vehicles that we see on the property?
Family, family, coworker, and friends. I mean, I could go through each one of them and try to point them out. If you'd like, I can go exhibit by exhibit, but they're really just family or coworkers.
Are they coming up there and using it when you're not there?
Based on exhibit 2 Echo, I'm going to say absolutely yes to that.
Okay. And then, so is the dirt, the land itself owned by the LLC?
Yes, sir.
Okay.
And I only did that. That's just the way we've done all of our real estate. So, I mean, if it needs to be transitioned into my name personally, I can do that. But I am the sole owner and manager of the LLC.
Yeah, no problem. And you don't dispute that it's that this is a residential G zone of about 10 acres?
No, sir. Do you mean current zoning?
Correct.
Yeah, no, sir. I do not dispute that.
Okay. tell me again, I'm just curious about that electrical hookup. So is electricity stubbed to the property line?
No, sir. To my knowledge, APS has power across Perkinsville Road. That's the closest that there is. I started the process with APS when I first bought the property. We kind of flagged it out and mapped it out where we wanted it to go. And they said that as soon as I get my building permit, they can run power immediately. But again, we started down that path. Building cost skyrocketed. We stopped. So did APS. APS won't bring in power unless I'm building a home, basically.
So where is that hookup? Is that across the street from your property?
No, the hookup referenced in 2 Bravo is on my property directly east of the concrete slab just across my dirt driveway, and it runs south to the generator. Every time I came out there, I would roll out extension cords, and I just got tired of doing it, so I just did that.
Okay. Mr. Stento, do you have any questions relating specifically to the questions I just asked?
I do.
Pardon?
I do not.
Okay. All right, with that, we'll close testimony. Mr. Stento, would you like to make a closing statement?
I would, sir. Would you like me to include the county's relief request in the closing statement or wait to address that separately?
Please include it in your statement, and I may ask you to follow up with an email.
I certainly will, sir. The evidence presented by Coconino County shows, based on the totality of the circumstances, the campground has been constructed at the subject address in violation of the county zoning ordinance. Moreover, the owner has clearly installed electrical, a commercial generator, and metal storage containers without permits. If the hearing officer cannot uphold the county's findings of a commercial use violation, the presented evidence also supports unlawful occupancy of multiple recreational vehicles, travel trailers, and fifth wheels on the property. Only a single permanent recreational vehicle, travel trailer, or fifth wheel can be occupied on a G-zone parcel, as I noted earlier, and it must be permitted. No such permit has been issued to or applied for by the respondent. Initial warnings were provided to the respondent more than 2 years ago, and the respondent's incomplete conditional use permit submittal at approximately the same time confirms the respondent understood the use was not lawful. Despite 2 years of compliance opportunity, as well as the Forest Service property nearby where camping is illegal, the respondent has persisted in perpetuating violations on the property season. Coconino County requests relief as follows. An initial fine of $605 due immediately, broken down as follows. $100 per day for confirmed campground and recreational vehicle occupancy use documented on 28 June, 05 July, and 15 July 2024, totaling $300. $5 per day for unpermitted electrical and metal storage containers documented on 19 June 24 through 19 August 2024, totaling $305. Item 2, an immediate stop to all campground use, including any use of recreational vehicles, travel trailers, fifth wheels, or the same as dwellings or accessory structures on a temporary or permanent basis. Item 3, removal from the property of all recreational vehicles, travel trailers, fifth wheels, or similar vehicles that are inoperable, unregistered, or stored for non-property owners. The personal vehicles of Mr. Hassett are fine. Earn Edit LLC or its agent, Mr. Hassett, will need to provide the county verification any remaining vehicles are registered, operable, and belong to Earn Edit LLC or himself. Item 4, removal from the property or permitting via the necessary building permits all metal storage containers, modified metal storage containers, and any electrical, gas, mechanical, or plumbing systems regulated by code. Further, if any incidences of campground use or the use of recreational vehicles, travel trailers, fifth wheels, or similar vehicles as dwellings or accessory structures on a temporary or permanent basis occurs within the next 30 days, Coconino County requests a $250 fine for daily documented occurrence. If items 3 and 4, which are removal of the non-personally owned vehicles and permitting or removal of the building permit items, are not fully accomplished on or before 23 September 2024, Coconino County requests a one-time $250 non-compliance penalty for each violation due immediately. For each day of non-compliance after 23 September 2024, a daily penalty of $20 per violation per day is requested. The maximum cumulative amount of penalties is $1,500. Should the daily penalty balance reach $1,500, the matter shall be forwarded to the county attorney's office for further legal action for the county zoning ordinance. And I will, of course, submit this to you in writing.
Will you please send a copy of that to Mr. Hassett as well?
I will.
Thank you. Mr. Hassett, would you like to make a closing statement to me?
No, I think I've said everything. I appreciate the opportunity though.
Okay. Just give me 1 second here. Okay, I appreciate the testimony today. I appreciate both of you being here and presenting your cases civilly. I'm going to take this matter under advisement, which means I'm not going to issue a ruling right now. I believe the zoning ordinance gives me 10 days to issue a ruling, but I will issue one as soon as possible, and that will be delivered to both of you as soon as I issue it. Any questions?
No, sir.
Okay. All right. Thank you very much. With that, I will close the hearing. Marty, will you please send me a recording of the hearing? And I believe Mr. Hassett requested one as well.
I will as soon as it gets converted by our team.
Wonderful. Thank you so much. With that, we'll close the matter, and I appreciate you. Take care.
Thank you very much.
Thanks. Thank you, Mr. Robbins.
It's like a stupid question, but I can't wait to work later.
Let us know when we're good, Marty.